To all, thanks for listening and thanks for watching. So basically today we are under the law of contract and we are going to look at consideration as an element of a valid what? As an element of a valid contract. And basically what you have to bear in mind or what you have to note is that here these elements are the ones that make a contract what? Valid. Once the contract lacks any of these elements, the contract is what? Invalid, or the contract is void. So we are going to look at consideration as one of the key elements of a valid contract. And note in mind that consideration can be defined under Section 2. Section 2 of the Contracts Act, whereby basically it defines it as the consideration is where one party is benefiting or one party is gaining profits or interest, whereas the other one is in a forbearance or is gaining loss or detriment. So bear that in mind. And basically consideration can also mean that here the parties, each side is giving a promise or is doing something or is acting upon the other's what? The other's promise or anything that you get. And the consideration was greatly defined in the case of Curie versus Misa. In the case of Curie versus Misa, they complemented to mean that consideration is where or it is a detriment to the promisor or a benefit to the promisor. It is a detriment to the promisee and a benefit to the promisor. So that's how the courts briefly defined consideration. And basically when you go to consideration, we mainly have two types. We have executory and executed consideration. When you go to executory consideration, basically executory consideration, it is an exchange of a promise, and it's an exchange of promises basically. You promise to deliver, I also promise to pay. That's briefly executory consideration. When you go to executed, basically here one party has acted upon, another one is what? Promise. It is an exchange of a promise and the act. Let me give an example of an executed consideration. Basically, when I tell you that you deliver me 80 bags of rice, when you deliver them, I'll pay 1 million or 2 million. Basically, it is an exchange of promise. It is executory. But at the moment I deliver those 80 bags of rice, which means I've executed my role. It makes it executed what? Consideration. You get? So bear that in mind. Those are the two types we have of consideration. However, consideration has various rules for it to be valid. These are the rules that we are going to look at of consideration. So basically, one of the rules is that consideration must not be past. Past consideration is not good consideration. So bear that in mind. When you read the case of Rimarcado, the case of Rimarcado basically defines that this widow had acted under past consideration and he couldn't be paid of the renovation he made on the what? On the house. You get? What do they mean by past consideration is that you do an act, but your payment comes in after. Take for instance, if you innovate a house, let me use even the example in the case. If you innovate the house, after innovating, I make a compliment that, you know what, I'll pay you your money. Actually, I've liked your work, but I will pay. I'll give you some amount of the money for the work done. That is past consideration. If I fail to pay, you cannot sue me because the consideration was past. It came in after you acting. So note that in mind. Then we have exemptions to that rule that consideration must not be past. First of all, we have the previous request. Previous request, this deals basically whereby there was a request before. I'll use the case of Lamplane versus Braithwaite. The other one, basically where Braithwaite killed and asked pardon from Lamplane. So after Lamplane getting pardon of Braithwaite, and he promised him to pay him a certain amount of money, but later he refused. But however, court held that the pardon that the money that was promised to the plaintiff acted on the previous request that was made by Braithwaite. You get, there was a previous request. You request here basically deals whereby someone makes a request. You know what? He tells you that, you know what? Help me clean for me my house. Then later in the day you clean the house. Then after he comes back, I'm going to pay you 100, which means that 100 amount of money is the consideration. But however, it is coming in after the previous what? Request, which means that cannot be what? Past consideration. Then you also have another exemption of business situations. Business situation, this deals in or acts in basically where we realize that sometimes you can act and be paid after, more so on promoters of a company, among business situations, so long as you're acting in developing of the company, you get. So that deals in business what? Situations. So their consideration sometimes cannot be what? Cannot be passed. When you read the case of recurses what? Patents. That's a good case on business situations. Then we have the Bill of Exchange. When you follow the Bill of Exchange Act, section, is it 26 to 27 there? From 25, 26, 27, and 28. Realize that sometimes the bank is in line to honor that check, regardless the time it is issued. What do they mean here? Realize that sometimes you do a certain work, but if they issue a check on you, you get your payment in the bank. There's no saying that consideration was what? Was passed. You get. So bear that in mind. You can present your check at any time in the what? In the bank. Yes, so those are some of the exemptions under consideration must not be what? Must not be passed. Then we have another rule that consideration must be sufficient but not adequate. And none need not to be adequate. Here what do they mean is that realize that there must be something of value. You understand? There must be something of value. So not that in mind. What do they mean by something of value? There must be a price. You get, when you read the case of Champel and Company Limited versus Neso Company Limited, here basically the essence or what they are meaning is something that is sufficient, is that something of value must not be there, must be there. Not necessarily that it must be adequate, but something sufficient, something of value, something that will bring detriment, you understand, to the other what? To the other party. So not that in mind. About consideration must be sufficient but not what? Adequate. And also not in mind that when you move on the sufficiency, is like, let me give an example, is that when you come and order 20 bags of posho or of flour, delivering them, that's the thing of what? Of value. You understand? Delivering them, I've delivered. So basically the consideration need not to be what? Adequate, but something that is sufficient. Then consideration must come from a promisee to the promisor. What do they mean is that the promisor must give the consideration to the promisor. When you read the case of Price versus Eston, realize that Price wasn't the one that gave consideration. That's why the case failed on grounds that he didn't give any consideration to Easton. However, Easton was with another what? Was with another party. So consideration must come from the promisee to the promisor. Then another thing where we see that there must be forbearance to sue. When you read the case of Alliance Bank versus Broom, forbearance to sue is basically there must be, in case of anything, there must be room to do what? To sue. Where there is forbearance is that you forego the thing of suing. There cannot guarantee what? A good consideration. So bear that in mind. Then there is also the existing of a public duty, where someone has a public duty or has a role or is mandated to carry out a public duty that cannot amount to a good consideration. I'll use the case of Collins versus Godfrey, where the defendant was was brought to court to give evidence, he had the public duty to come and witness and give evidence in court. But however, you realize that the plaintiff sued because the plaintiff was the one who was supposed to be what, to give evidence. So he sued the defendant on grounds that he had promised to pay him money in case he went to court to give what, evidence. Here, court, the suit failed on grounds that he had already a public duty to do so. So there was no good consideration. But however, there is always a good consideration if the existing public duty is exceeded or exceeds. You get? So note that in mind. I'll use the case of Glassbrook Bros versus Glamorgan County Council or GCC. Basically, here realized that it was a police duty to keep order in the premises. So here the defendant went ahead and promised them money in case they provided maximum security to the premises. Then when he failed, he lamented that it was a public duty for police. It was the police duty to provide security. But however, court held that it was their duty to carry out security in their own way. But however, the defendant had paid them, had exceeded their public duty in instructing them on how they can conduct security. Hence, this mounted to what? A good consideration. You get? So note that in mind. And also another rule where there is existing contractual duty, there is no good consideration since it is a contractual duty between the two parties. Then where there is a part payment of a debt, you get? Even before existing contractual duty, it is not a good consideration. But existing contractual duty owed to a third party, if a third party carries out a duty on behalf of another or on behalf of a second party, then it becomes a good what? Consideration. So note that in mind. Then we also have part payment of a debt. Where there is part payment of a debt, there is no good what? Consideration. You get? Part payment of the what? Of a debt. It is not a good consideration. So note that in mind. However, where there is payment of a lesser sum or a part payment by a third party is treated as a certification for a greater sum. You get? So note that in mind. So basically, those are some of the rules governing consideration as an element of a valid what? A valid contract. But thanks for watching. Thank you very much.